Once again, hello everyone. Thank you very much for your interest to our topic today and for joining our webinar. We appreciate your time and we'll do our best to be as much helpful as it's possible. Today's topic is doing business in Azerbaijan. We are going to discuss the main points, of course, taking into account that we will be holding this webinar for 1 and maximum 1.5 hours. You'd appreciate that it is not possible to discuss all relevant points for those who are or considering to take a decision on whether to invest in Azerbaijan or not. And definitely for those who are already in the local market, business has its own practice, concerns, and issues that are obviously not possible to be covered within 1 and 2 hours. But still, feel free to ask your questions in the question and answer section under the screen. We will be having 4 presentations. I'm a managing partner of Grata International Law Firm's Azerbaijan office, Ummi Джалилова. I'm here today with our senior associates, Шабнам Садыгова, Роял Ибрагимли, and our junior associate, Фатима Эйюб. Each of them will be talking about their field of expertise and those fields that raise most questions from both investors and those that are already in the local market, both potential investors and those are already represented in Azerbaijan through their subsidiaries or representative offices or branches. We will be trying to cover all questions, address them at the end of the webinar. However, in case we run out of time and have still questions not answered, we'll make sure we respond to them through emails sent to you after the webinar. Thank you again. So, doing business in Azerbaijan, I will be the first speaker for today's webinar. Usually, the first question is why an investor should consider investing in this region in general, in Azerbaijan in particular. Well, Azerbaijan has been attracting for its favorable geographical location. Azerbaijan has been traditionally called a bridge between East and the West. And its favorable location has been attracting, especially for those in the transportation business, logistics, and etc., but not only for them. As you know, Azerbaijan is one of former Soviet Union countries that regained its independence since 1991. And since then, economy has been displaying growth with a speed that had not been observed ever before. Both government efforts introducing legal, economic, and social reforms and growth of economy by objective factors, having many countries represented in the local market through their companies and partnering entities, resulted in constant growth to making the country more comfortable, convenient for both local entrepreneurs and those coming to the country from abroad. You also know that this country is rich in natural resources. Oil and gas has been the traditional field of investment for many years for foreign investors. And we should admit that for many years, government also was not happy with state's economy being heavily dependent on the income from oil and gas sector. And as a result of this, since 5-6 years ago, we have been witnessing constant legal reforms in the direction of making investment in other areas of economy more attractive in terms of privileges, simplified approach by the regulatory bodies, and some benefits have been introduced especially for purposes of promoting local production and manufacturing, to make Made in Azerbaijan brand, for example, known abroad and goes widespread in the foreign markets. So as a result of this constant efforts by the government, now what we see is that fields of businesses like agriculture, logistics, transportation, tourism are now displaying more statistical indicators with representation of foreign investors in the country. Another reason why investors usually highly rank the country high in their tables and lists of countries is safety. Azerbaijan is really a safe country, both for individuals and businesses. And if to not take into account a war that we had for a short time, but still in 2020, as a result of which we, of course, regained control over the territories that had been occupied for almost 30 years. Since 1991 or 1994, from the date of ceasefire agreement between the two countries, Azerbaijan has been showing very safe, stable features for both foreign individuals, foreign citizens, persons without citizenship, and big companies represented in many jurisdictions to consider setting up at least one office in Azerbaijan and exploring the possibilities and projects with an aim to make profit here as well. The country is known for vast majority of people being Muslims, but Constitution of the country declares that the state is a secular state. We do not have strict religious people in big number in the country, and overall, since Soviet Union times and even before, Azerbaijani people has been known for displaying high level of tolerance to representatives of other beliefs and religions. So even on day-to-day level, in personal relations with local residents here, traditionally it has been very easy to get along with local people, to have neighbor relations or business relations with local people here. And countries represented by citizens and non-citizens belonging to different ethnic groups and religions and sectors within the religions. Ease of doing business. Well, World Bank has regarded Azerbaijan as 34th country in its ranking list out of 190 countries for ease of doing business. And that was achieved, we believe, as a result of constant economic, legal, and other reforms in the country in the last few years, I can say 5-6 years mostly, and these measures are continued and ongoing also. If to speak from safety for businesses standpoint, Azerbaijani laws in general and the law on protection of investment in particular provides for state guarantees for foreign investors doing business in Azerbaijan. According to the laws, foreign investments in Azerbaijan enjoy full and unconditional legal protection, and the legal ground for that is not only made of the local laws, but also international treaties. We have many of them where Azerbaijan is one of the signees of those treaties, which means Azerbaijan has taken this obligation in relations and before many countries and many states that their residents, companies incorporated in those countries will enjoy the equal protection in Azerbaijan as compared to the local investors. Azerbaijani laws further declare that if in future legislation changes in a way that it worsens the investment conditions, government and state guarantee that the legislation that was in force at the time of the investment will continue being applied, will keep being applied for 10 subsequent years from the date of those changes. There are, of course, exceptions. These are changes made to the law with an aim of defense of national interests, national security, public order, taxation, loans and finance, and morality, health, and environmental protection. But still, even in those areas, we do see that government officials, they do treat foreign investment with more sensitiveness than they would approach local investors, businesses. State further guarantees that foreign investments in Azerbaijan, they cannot be subject to nationalization. Again, exceptions are possible, but those are very rare cases. These are the cases that may cause damage to the people and state interests of Azerbaijan. But even if that is the case, when subjecting the business to nationalization, government or requisition, which is basically government taken for public purposes of the private equity assets, and etc., government ensures that the investor receives adequate compensation, and this compensation should correspond to the real value of the investment at the time the decision was taken by the government to take the asset, property, or the business in whole. One of those attractive points for businessmen currently, for foreign business people and investors, also is that now we have many more opportunities and projects to invest in Azerbaijan. And that is also related to, as I mentioned, release of occupied territories from occupation since 2020. Azerbaijan's government is putting tremendous efforts to rebuild those regions, those cities and rural areas from basically zero, which means we have many projects, some already declared through tenders, but many more on the way to be introduced in different fields of economy. That means construction, of course, in the first place, infrastructure, healthcare, schools, and etc. So we will touch this a bit later. We will talk about this a bit later, but people that are already in Azerbaijan, they do know how to access the open projects database through their consultants or directly via the Ministry of Economy. For others, unfortunately, there is no open online portal where they can see opportunities open for investment. And that is something we really hope to be fixed in near future. But generally speaking, those investors that are really seriously interested in investing in Azerbaijan, they can find a source where to receive the information about details of the project and the requirements of the state applicable to the investors. State also guarantees that compensation when paid to foreign investors in foreign currency will be regarded as legitimate, although, as you know probably from practice, in Azerbaijan, the transactions are and payments made in local currency, Azerbaijani manat, but when it comes to foreign investors, their employees, their companies in Azerbaijan, there is an exception applied to them, which basically means they are free to make certain transactions in a foreign currency. And one of the state guarantees is that compensations can be made in foreign currency to the investor at the end of doing business in Azerbaijan, or as a result of those cases that I mentioned a bit earlier, government taking or nationalization, or etc., can be made, can be paid in a foreign currency upon request of an investor. And if the investor so desires, the payment should be transferred to a bank account of the person or a legal entity abroad. Foreign investors have a right to not only the compensation for actual losses, but also for lost profit. But in case if the damage is a result of actions or inactions by the state officials. In other words, if you suffer from illegal actions of the government bodies, then you are entitled to receive a compensation, not only for the loss you suffered, in fact, but also for the loss that you suffered in terms of loss of profit, potential profit that could have been gained if state officials didn't act the way they did. State also guarantees fair resolution and adjudication of disputes between foreign investors and local investors, local business people, also between the foreign investors and the government of Azerbaijan. The place of dispute resolution can be both Azerbaijani courts and, upon choice of parties to the agreements, foreign courts or arbitral institutions. Here, the important thing to note that there is not a long, but still there is a list of cases that would fall under exclusive jurisdiction of local courts, which basically means that those cases may not be taken out of Azerbaijan, and it will not be possible to subject them to the review of foreign courts or arbitral institutions. But other than those, parties are always free to choose the dispute resolution forum and panel in their business agreements. And if nothing negative has happened in Azerbaijan, just foreign investors, they conducted their business, received dividends or other income, compensations from the government or natural persons in Azerbaijan or other business entities. They are always free to take the amount owed to them through legitimate channels, meaning through bank payments, depending on the amount, of course, but normally that is through cashless transactions from bank account to the bank account of an investor. And it is possible to transfer the dividends or we call this repatriation of investment. If the company has been, for whatever reason, liquidated or dissolved by the investor after doing business in Azerbaijan, the residual value in the cash form, what is left in the bank account, is easily transferred abroad to the founders, shareholders or shareholder companies' bank account in a foreign state, provided that before applying for such transfer, the foreign investor has already paid taxes, state duties, fees, customs, and other payments owed to the government. Now I'll try to talk a bit about the legal forms of doing business in Azerbaijan, and those most popular forms have been limited liability companies, joint stock companies, open and closed, branches and representative offices. Actually, it will be a long discussion to talk about features of each of these forms. And if we compare them, we have different criteria for comparing them. By the way, if you'd like to receive detailed list of those criteria and how each of the legal forms differs from others, please let us know. We'll be happy to share that document. But in general, if we talk about LLCs and JSCs versus branches and representative offices, please note that limited liability companies, joint stock companies, also additional liability companies, if you happen ever to see such a legal form used in Azerbaijan. Why I'm saying this, because the law has been permitted for this since adoption of the civil code, but it is very rare in practice for an investor to be willing to assume additional liability, which means above the charter capital and assets of the entity established in Azerbaijan. Nonetheless, additional liability companies, LLCs, joint stock companies, partnerships, they are considered as independent legal entities in Azerbaijan. While if you compare to branches and representative offices, the latter is not a legal entity under Azerbaijani civil code. Branches and representative offices are rather regarded as subdivisions of a foreign legal entity in Azerbaijan, if of course they indeed were established by foreign investors. And even between these two, branches and representative offices, their scopes of businesses, volume of businesses, and the extent of scope of services and works, they differ in between themselves as well. For example, I'll try to make this clear. Branches and representative offices, they both are subdivisions of a foreign legal entity. However, branches, they are permitted and allowed to be engaged in the same field of business, to offer exactly the same services or perform works that match the founding company's business. Branches are free to offer part of those services in Azerbaijan, meaning to be engaged in the mother company's in the business similar to mother company's business abroad, partially, not fully. Unlike branches, their representative offices, they are also, although they are also subdivisions of a legal entity, they are not allowed to offer services, to perform any works or manufacture goods. In other words, profit-making business is not a right format for representative office. This is what the law says, and this is the requirement of civil code. Usually what we have in practice, representative offices are established with the pure purpose of representing the legal entity in Azerbaijan, for introducing the business, introducing the head company that can potentially offer goods or services from abroad to the clients in Azerbaijan. That is the easiest, simplest, and the most correct way of doing business through representative office. However, in practice, you may see many representative offices in Azerbaijan that are engaged in a traditional full money-making business. By this, we mean if you compare regular branch and one of those representative offices that I just mentioned, you will see that representative office is doing exactly the same, and the volume of services, the scope of services doesn't differ, and they receive payment for the services and works performed in Azerbaijan. Why this has been possible despite the law restricting them in this? Well, probably because first, the mechanism of control is not strict. Second, because they have been making payments on time. I mean, tax payment, customs, and other charges and fees. And since the registry of state legal entities is maintained by the tax service under the Ministry of Economy, the Ministry of Economy and the tax service are mainly interested in collection of debts timely and in full amount. Once the entity has done that, they are not interested in approaching their representative offices for leading them to restrict their scope of services or works. Maybe that is good. That is one of those signs that show that government is not interested in putting undue burdens on the businesses. But this is how it is. I mean, the law says representative offices may not make money in Azerbaijan, basically, but in practice, we see a different picture. Business entity classifications are not only based on the scope of work and business and the services, legal forms, etc., but also in on the size of businesses, which matters for the purposes of taxation and other requirements of the law. In Azerbaijan, we have micro businesses with annual revenue not exceeding 200,000 manat, and with the number of employee not exceeding 10 persons. Small enterprises, they generate revenue from 200,000 manat to 3 million manat, and the number of their employees is from 11 to 50 persons. Companies with the revenue from 3 million manats to 30 million manats and employees above 51 but less than 250 people are regarded as medium-sized businesses. And finally, we have large businesses with the income revenue, in amount exceeding 30 million in a year, and employees above 251 persons. I'll try to go through this slide very quickly because this is more about procedural matters. How long does it take to register a company? This is one of those first questions we receive from the clients willing to set up a business in Azerbaijan. First of all, establishment of a company is possible through the online platform on the website of the Ministry of Taxes, and by submission of hard copies of the registration documents. Usually it doesn't take more than 1 to 2 business days after submission of the document package, provided that, of course, all documents are in place and nothing is missing. But sometimes, in rare cases, it may take for a few more days. This we mostly observed during the pandemic, but that is normal. Government entities were working with 30% of their staff. Document package should include resolution on establishment of the company, on appointment of the head, director, or whatever name you choose, title you choose for the position, on approval of the charter or regulation, depending on the legal form, on approval of the legal address. If the company is going to be registered through the third parties, and those are usually local consultants of shareholders in Azerbaijan, then document package should also include a power of attorney in the name of those consultants or other persons who will be approaching the tax service on behalf of the shareholders. If the chosen legal form of doing business is an LLC or joint stock company, then ID or passport copy of a future director will suffice. But if you chose branch or representative office for your future business in Azerbaijan, then along with the ID or passport copy of a future director or top manager, we will need to receive a POA from you. By you, I mean the shareholder or investor. We will need a POA issued by shareholders, participants of LLCs or founding company, depending on the structure of business, in the name of a future director of the new company or branch or representative office to be registered in Azerbaijan. We will also need to see and translate, along with all other documents, into Azerbaijani and notarize here before submission to the Ministry of Economy, a POA from those directors in the name of local consultants or other persons who will be conducting the registration, appearing before the Ministry of Economy on behalf of the future company. That POA should basically include an authority to represent the director in signing the documents in the state tax service. Overall, this means director agrees to be appointed to this position, and in addition, he delegates some of his authorities to sign documents on his behalf when applying for registration of him as a director of a new entity. And at last but not the least, we need to include receipts proving payment of state duty for registration in the same document package that will be submitting to the state tax service. By the way, before I forget, we will need shareholders documents as well. Those are regular corporate documents, extract from the trade registry or legal entities registry, whatever is the right name for a particular country where the shareholders business was incorporated. Certificate of registration, article of association or charter. We will just receive their postal copies or legalized copies and translate along with other documents into Azerbaijani, arrange for the notarization of them in Azerbaijan, and submit to the state registration authority. For the entities that have a legal form of LLC or branch or representative office, we just need to approach one state agency, which is, as I mentioned, state tax service under the Ministry of Economy for registration of a business. And once all documents have been submitted, we wait for a few days and then collect the registration documents. And those are certificate of registration, extract from the registry, charter or regulation of the company approved by the Ministry of Economy. For joint stock companies, however, we need to go for one more registration, which is registration of stocks with the central bank and National Depository Center. This is the registry of securities. And in Azerbaijan, shares, stocks, and JSCs are obviously regarded as securities. And the entities responsible for maintaining that registry is a central bank and National Depository Center. By the way, this is, although required by the law, you will see many companies in practice with an experience of doing business in Azerbaijan for many years, registered maybe 15 or 20 years ago, but still not registered its stocks or shares with the National Depository Center. Again, the answer to the question, why so, will be due to lack of control. But since recently, we have been observing closer watch of this by both central bank and the state tax service. Maybe we'll talk about this a bit later, how this happens in practice. Charter capital. We don't have to have charter capital paid before approaching the state tax service for registration of an entity. We can show the amount, we have to show the amount of charter capital in the charter of the company that we submit for registration. But factual payment can be made within 3 months of the day of registration of the entity. One of those important points is to ensure that all documents issued abroad are sent to Azerbaijan after passing legalization in the consulates of Azerbaijan abroad. And if the country where the documents are issued happens to be a party to the Hague Convention, Postal Convention, then Azerbaijan will accept a postal document instead of legalized documents in consulates abroad. And in case the country of incorporation of the founder's business abroad happens to be a country with which Azerbaijan has either bilateral or multilateral agreement on avoidance of apostolization legalization requirement, then simple notarization in those countries will suffice. And these are countries mainly from former Soviet region, which we now call CIS, Commonwealth of Independent States. Turkey, with Turkey we have bilateral agreement, and few other countries. So simple notarization from those countries will be enough for the registration purposes in Azerbaijan. Registration fees for different forms of companies, entities in Azerbaijan are as follows. You can see on the screen, branches or representative offices of foreign legal entities are subject to 300 Azerbaijan manat at the time of registration. LLCs, joint stock companies, and other legal forms can be registered by payment of 15 Azerbaijani manats. And as a simplified approach to the agriculture field in general, entities willing to conduct any business in the field of agriculture, they can have their businesses established and registered only for 5 Azerbaijani manats. I know I'm running probably out of time slightly, so I'll try to be quick. After registration of the company, we have to keep eyes on subsequent changes in the course of business. Any change, director change, legal address change, any change in charter capital, which will ultimately and has to be reflected in the charter itself. And other changes of data registered with the state legal entities registry have to be duly registered as well. Failure to do so will be treated as a breach of the law on registration of legal entities and state registry regime. Registration should be done. The company should apply for registration, let me put it in a correct way, within 40 business days following the date of change. If not applied on time or not applied at all, and this fact has been found later by the government agency responsible for the registration, the fines, administrative fines in amount from 1,000 manat to 2,000 manats applicable to individuals, authorized persons of the entities, and 2,500 manat to 3,000 manat may be applied to legal entities. So application of, let's say, 2,000 manat fine to the head of the business does not release the entity from the fine that is applicable and has to be applied simultaneously to the entity as a legal entity. So to avoid these fines, it is important to make sure that changes are timely filed for registration. Some activities and businesses in Azerbaijan fall under licensable categories of businesses, which basically means licenses or permits are to be obtained for the company to conduct the business. Breach of the requirement is considered to be an illegal entrepreneurship in Azerbaijan, and such actions or inactions, actually, not applying and not obtaining license, and without such licenses, conducting businesses, providing services, works, or manufacturing goods, will be considered an illegal entrepreneurship and are subject to either administrative measures or even criminal penalties, depending on the amount of damage made or profit gained through illegal entrepreneurship. Penalties and sanctions may be both in the form of fines under the administrative code or even criminal code, or if the amount constitutes a criminal misconduct, then penalties in the form of restriction of freedom may also be applicable. So before I give the floor to another speaker for today, I would like to very quickly go through the frequently asked questions, and few of them were also asked to us in the last 2 days. When registering for the event, some of the listeners sent their questions through an email. So we would like to go through them. I'll try to answer in short, but of course, if further questions arise, please feel free to send them as well. Can a foreign company or individual be a founder of a company in Azerbaijan? Short answer is yes, as we discussed. A foreign company, both foreign companies, individuals, foreign citizens, or persons without citizenship, foreign governments, states, international organizations can be founders of a business in Azerbaijan. Moreover, they can be founders together with local residents, if they choose to do so, by sharing the portfolio, by sharing the stocks, or they can be 100% owner of the business. Foreign investment is possible through both establishing, setting up, and registering a new entity together, or together with locals or other foreign investors, or alone, and through acquisition of share in already existing businesses in Azerbaijan. So the answer is yes. Any restrictions? Restrictions, well, residency-specific restrictions almost do not exist. There are some restrictions in terms of what types of businesses may be conducted by foreign shareholders companies in Azerbaijan. There are only few restrictions. For example, cartography activity, cartography business. Government will not issue a permit to a foreign-owned business in Azerbaijan. It is not a subjective approach, it is directly in the law. A business that applies for permit or license in cartography activity should 100% belong to a local resident, individual or legal entity, doesn't matter, but not a foreign business. One other field of such restriction is media activity. Not all services and works, of course, are restricted, not at all. Ownership over TV channels and offering media services through TV channels, which are going to be fully owned by the company that itself belongs 100% to foreign shareholder, is not possible in Azerbaijan, and that is also in the law. So we have maybe few more of similar restrictions, but generally speaking, there are a wide variety of fields of doing business in Azerbaijan without no restriction at all. that would be based on the residency or citizenship requirement. Second question, what is the minimum charter capital required? Generally speaking, 99% of the business areas and legal forms do not require any minimum charter capital. I mean, there is no set minimum charter capital expected from the shareholders. There are again few exceptions that we have both in the line and practice. These are banks, obviously, as perhaps in any country. There are set minimum charter capital amounts for an entity that is going to be offering banking banking services. Before registration, they have to ensure that the minimum required capital is available and already invested. Non-bank credit organizations will also fall under the same requirement. Insurance companies, few more entities will have to satisfy the minimum charter capital requirement. Other than those, there is really no such a requirement for startup businesses in Azerbaijan. Your charter capital may be, amount of charter capital may be as small as 10 manat or 15 manat or even less. What legal forms you would recommend to choose? That is a difficult question. Without getting familiarized with your business plan, with your potential projects in Azerbaijan, even not the projects themselves, but the goal and the purported businesses, anticipated directions, if I have put that in the right way, in the correct way, without having any information about what you would like to do in Azerbaijan, what is going to be your company's business, services, and works offered by that company in Azerbaijan, it is difficult to recommend anything. We do recommend, of course, but on case-by-case basis. This may be different. There is no one-fits-all recommendation. So if you already have some plans and you don't mind sharing non-confidential, at least part of the information, you can send them to us and we'll be happy to assess and let you know our view. Does a company have to have a legal address? Does office address have to be the same? It is must. Legal address is a must. Even at the time of registration, if a resolution does not mention a legal address, or if the charter or regulation of the company submitted for registration purposes does not include an article with legal address, this entity will not be registered. And at no point after registration, a company may be without a legal address. That is a mandatory data to be included in the state legal entities registry. And an entity has to have legal address. As for whether the office address have to be the same, no, not at all. There is no such requirement. Although you may find it more comfortable to have both addresses the same for receiving your mails, government notifications, maybe court notifications, so that no mails are lost. But other than those concerns, there is really nothing to take seriously into account that would derive from the law, which should lead us to believe that legal address should be the same as factual address. What is important here, however, is to ensure that any change in the legal or factual address is timely registered. Because, as I mentioned earlier, changes in the registry data, which includes also legal address, is to be done within 40 business days from the date of change. And if not done timely, such failure may result in administrative fines. As for factual address, that also has to be registered, but this is a different registry. This is not a state legal entities registry. Office address is registered with also tax agency, but the agency's structural unit responsible for control, collecting of taxes, etc., of that category of companies. Categories are usually based on size, local investment or foreign investment, that doesn't matter. My point is that there is a separate registry for office address as well. Through e-taxes Govas, you may be able to see that if you already have a company in Azerbaijan. And although potential fines are in much less amount, but still there is an obligation to timely register the factual office address in case that is changed in the course of business. Next question, do all entities have Azerbaijani taxpayer status? Well, generally speaking, all entities in Azerbaijan have to pay taxes. All individuals in Azerbaijan have to pay taxes from their income in Azerbaijan. Or if Azerbaijani citizens, they are obliged to pay taxes even out and from their income made abroad. But if the question is about status of a taxpayer, then as we discussed before, LLCs, joint stock companies, partnerships, all those that are considered as legal entities in Azerbaijan, they have Azerbaijani taxpayer status, local taxpayer status. Branches and representative offices of foreign legal entities in Azerbaijan, they are regarded as permanent establishments of foreign non-resident taxpayer. May companies start rendering services, licensable services, immediately after submitting an application for obtaining a license? Short answer will be no. It is not enough to have the application for licenses or permits submitted for being able to get actively engaged in the licensable business. In other words, application is a first step, but before actively offering and rendering services or performing works or manufacturing goods that fall under licensable categories of businesses in Azerbaijan, an entity has to have a license available already. Because, and this is the area where we observe strict control by the tax agency in the first place. There are inspections and tax audits conducted with the aim of determining whether the company started to conduct business after obtaining licenses and permits required and applicable to that particular field. I hope my presentation was helpful. Sorry for taking, I believe, more time than it was initially planned. But if you have any questions, and I do see already questions in QA section, please send them through the QA section or chat box here under the screen. We'll be happy to answer to those questions at the end of the webinar. Now, I would like to pass the floor to my colleague, Mr. Royaal Ибрагимли. He will be discussing taxes and related requirements of Azerbaijani law as applicable to foreign investors. Thank you very much. Royaal, the floor is yours.
Hello, everyone. Thank you for joining us today. Let me share my presentation. So it is very important for foreign investors to be well informed about tax system of a country where they are going to invest funds before entering the country. In this presentation, I will cover the main points of tax and regulatory regimes in Azerbaijan. The tax code is the main and primary legislative act governing tax matters in Azerbaijan. And in some instances, for example, import with excise tax is also regulated by the customs code. When it comes to administration of taxes in Azerbaijan, the state tax service is the main state body responsible for administration and collection of taxes. In respect of import weight and excise tax, the tax control is also conducted by the state customs service. In this slide, we will discuss the tax regimes that are available in Azerbaijan. Three separate tax regimes currently are available in Azerbaijan. The first one is the statutory tax regime, which is governed by the tax code and customs code. So under this tax regime, tax base, tax rates, tax filings are specifically regulated by tax code and in some cases by customs code. A statutory tax regime contains two subcategory tax regimes. The first one is simplified tax regime. The second one is profit tax and VAT regime. We will discuss these two sub-regimes in the next slides separately. The second tax regime is the special tax regime, which applies to oil and gas companies operating under production sharing agreement and post-government agreement. PSAs and HGAs provide lower tax rates and other tax benefits for the entities that are parties to this agreement. And the third tax regime is the temporary tax regime, which has been recently introduced to the tax code in light of COVID-19 pandemic. This tax regime applies to taxpayers affected by a force majeure event and mainly provides lower tax rates, tax deductions, and extension of deadlines for submission tax reports. Simplified tax regime provides also lower tax rates and certain conditions shall be met to enjoy this tax regime. The first condition is that the entity shall not be a VAT payer, and the second condition is that the entity's turnover shall not exceed 200,000 threshold. So there is an exemption from this threshold. Entities providing public catering services may still benefit from simplified tax regime even if its turnover exceeds the threshold. As a rule, the simplified tax rate applies to the whole turnover of an entity, and meaning that tax deductions are not allowed under this regime. Certain businesses are required to be registered only as simplified taxpayers. These include providers of domestic transportation services, sport betting, lottery operators, sellers of lottery tickets. In other words, this category of taxpayers are not eligible for corporate income tax. And certain businesses cannot be eligible for the simplified tax regime. These businesses include persons who produce accessible products, for example, alcoholic beverages, tobacco products, banks, investment funds, insurance companies, persons receiving income from royalty payments, and use of property. In other words, this category of businesses can only be registered for corporate income tax purposes. We'll briefly go through some examples of profit weight tax regime requirements. The mandatory weight registration is triggered when an entity's taxable turnover exceeds 200,000 Azerbaijani manat during any month of a consecutive 12 months period. The entity may benefit from voluntary weighted tax registration even if its turnover does not reach this threshold. When compared to simplified tax regime, under this tax regime, deductions are allowed, meaning that the expenses with respect to income generation can be deducted from the revenue. Profit tax rate in Azerbaijan is 20% and standard weight rate is 18%. It is also very important to know tax incentives of a country where investors are going to invest their funds. Azerbaijan tax code also provide certain tax incentives, for examples in agriculture sector, for SMEs, educational services, for startups, technological industrial parks, and export promotion. The last one, the export promotion, is provided in particular with respect to non-oil and gas products to promote export of these products outside the country. We'll briefly go some examples of these incentives in the next slides. For example, corporate incentives from corporate income tax. 75% of income of micro businesses is exempt from corporate income tax. In addition, profit of startups are exempt from the corporate income tax. This exemption applies only for 3 years period from the date of receipt of startup certificate. 50% of the income of a company received from the sale of its shares is also exempt from corporate income tax, provided that such shares is held by the company for at least 3 years period. In this slide, we can see certain personal income tax incentives. So, for example, salaries of employees up to Azerbaijan month 8,000 who work in non-oil gas and non-public sectors are taxed at a rate of 0%. Dividend income of an individual, he is the shareholder or founder of a micro business, is also exempt from personal income tax. And 50% of an individual's income received from the sale of his shares is exempt from personal income tax, provided that such shares are owned by the individual for at least 3 years. VAT incentives are divided into 2 groups. The first group is full VAT exemption, and the second one is zero rate VAT. Some examples of full VAT exemptions, exempted transactions are contributions to charter capital, provision of financial services, provision of paid education services, transfer of share in a company, imports of residents of industrial technological parks, import of sale of hybrid cars, import of second and third level electric chargers for electric cars. These last two items related to import and sale of hybrid cars and the electric chargers have been recently added to the tax code with effect from January 2022. And in this slide, you can see some examples of zero rate VAT. They include freight forwarding services related to international and transit cargo transportation, export of goods, export of certain services, for example, accounting, legal, telecommunication, and similar services which are rendered through internet platform. Double taxation is also very crucial for investors when entering into the market. So the government of Azerbaijan has entered into double tax treaties with 55 countries. The implementation mechanism of these double tax treaties in Azerbaijan is specifically regulated by the resolution of the State Tax Service. Non-residents who wish to benefit from double tax treaties should follow certain formalities, even if there is a double tax treaty. So the local regulation provides three options for non-residents in order to enjoy from double tax treaties. The first option is DTA3 application form. For DTA3 application form provides full exemption from withholding tax or application of a lower tax rate. So non-residents should file this application form to enjoy advanced exemption or a lower tax rate provided in the double tax treaty. And the second option is DTA4 application form. This application form is submitted to the local authority, tax authority by non-residents for the confirmation of taxes that they have already paid in the Republic of Azerbaijan from their incomes generated from Azerbaijan source. And the third option available under the regulation is DTA5 application form. This application form is submitted by non-residents for the purposes of refunding their overpaid tax in Azerbaijan. For example, if the double tax rate provides lower tax rate or full tax exemption, but the non-resident didn't benefit from this exemption and paid full amount of taxes required by local tax code. And by filing this application form, the non-resident may refund the overpaid tax. For all these application forms, shall be accompanied by supporting documents. Supporting documents may include contracts between resident and non-resident entity, a residency certificate of the non-resident entity, invoice, handover acts, and etc. The application forms can be submitted directly by non-residents or through their legal representatives in Azerbaijan. So this is the end of my presentation. Thank you for your attention. I would be happy to answer your questions if any. Thank you.
Thank you, Royal, very much for your informative presentation. Now I would like to give the floor to our junior lawyer, Fatima Eyyub, to discuss financial requirements of doing business in Azerbaijan and those frequently touched topics by foreign investors and government officials in interactions with government investors. Fatima, please go ahead.
Thank you. Hello, dear participants. So through my presentation, I will cover financial regulations and currency control rules applicable to business entities entering the Azerbaijani market and having activities there. Let me share my screen. First of all, I would like to give an overview of the country's financial state. The currency of the country is Azerbaijani manat, which is currently equal to 59 pennies and 52 cents. And the main legislative acts regulating foreign exchange transactions and currency flow are the law on the currency regulation, law on cashless settlements, and others that are noted on the left side of the page. The main finance control authority administering the overall enforcement of currency regulation in the country is the Central Bank of Azerbaijan. The financial development index of the country, which is determined through consideration of accessibility of financial services by companies and individuals, as well as by ability to provide financial services at low cost and sustainable revenues and other related criteria, is 0.19 out of 1, according to the latest report of the International Monetary Fund, in comparison to 0.16 out of 1 in 2016, and is increasing day by day. The currency law divides the subjects of currency transactions into residents and non-residents. So individuals having permanent residence in the Republic of Azerbaijan, legal entities established in accordance with Azerbaijani legislation, and their branches and representative offices located outside Azerbaijan, as well as enterprises and organizations that are not legal entities, are located in Azerbaijan and are established in accordance with Azerbaijani legislation, and their branches and representative offices also located outside Azerbaijan, are considered as residents for the purposes of currency regulations, while individuals having permanent residence outside the Republic of Azerbaijan, legal entities and enterprises and organizations that are not legal entities, established in accordance with foreign laws located outside Azerbaijan, and their branches, representative offices, bureaus, agencies located in Azerbaijan are considered as non-residents. Now, I would like to talk briefly about the legislative regulation of settlements and bullet points regarding them, as well as I would like to list a few of the settlements that shall be carried out exclusively in the cashless form. So payments for settlements with the total amount more than 30,000 manat within a calendar month by taxpayers registered for VAT purposes, and taxpayers engaged in public catering activities with the volume of taxable transactions more than 200,000 manat in any month or month of consecutive 20-month period, and payments for settlements with a total amount of more than 15,000 manat within a calendar month by all other taxpayers shall be carried out in cashless form. Also, payments for pensions, salaries, reimbursements, compensations, etc. by persons other than persons operating in the field of catering, retail trade and services, with the volume of taxable transactions up to 200,000 manat over a period of consecutive 20 months, and payment of taxes, customs duties, administrative penalties, financial sanctions, etc. shall also be carried out in a cashless form. It should be noted that transfers between two bank accounts, depositing funds into a bank account, transfers carried out through technology such as telephones, computers, and payment terminals are considered cashless settlements. According to the report of the World Bank for 2020, only 28.6% of the population over 15 have bank accounts in Azerbaijan, while one of the main goals of the country is becoming a completely cashless society by the end of the decade. With this in mind, the law on cashless settlements has been subject to significant changes recently, after which new payment categories that shall be carried out exclusively in the cashless form were determined. These include winnings from lotteries, for example, over 3,000 manat per transaction, as well as payments for retail shopping over 3,000 manat per transaction. When it comes to bank accounts, residents and non-residents can open and maintain bank accounts in local and foreign currency in the Republic of Azerbaijan. Opening of bank accounts is carried out through submission of documents to the bank. The list of documents depends depending on whether the applicant is a resident or non-resident, is a legal entity. Include a notarized copy of the charter of the legal entity, extract from the state register of the legal entity with most recent changes, duplicate certificate issued by the tax authority, and a writ of signature and seal. Notarized copies are not required if the documents may be obtained through the electronic information systems of relevant registration bodies. In such a case, originals may be brought to the bank, and the bank officers will scan the copies and check the information with the information kept in electronic information systems. All documents shall be submitted in hard copy and or certified with enhanced electronic signature. Azerbaijan has a quite strict control mechanism over foreign currency transactions, although no restrictions apply to transfers of funds to Azerbaijan, and no restrictions apply on transactions in Azerbaijani manat. Cash transactions in foreign currency, as well as transfer of funds from the country, are subject to several restrictions. Thus, cash transactions in foreign currency are not allowed within the territory of Azerbaijan, and the transfer of funds in foreign currency without opening a bank account is prohibited to legal entities. Only individuals can carry out such transactions. Transfer of funds from Azerbaijan without opening a bank account and through a bank account but for personal purposes is subject to restrictions related to transaction amounts. Transfer of funds from Azerbaijan via bank account and not for personal purposes is carried out with submission of supporting documents to the bank, such as contract, invoice, customs declaration, and is not subject to any restrictions related to transaction amounts. Azerbaijani legislation allows transfers by non-residents or in their favor for the purpose of repatriation of foreign investments made to the economy of Azerbaijan. Such transfers are made by submission of the documents to the bank. These documents include the customs declaration confirming the import of funds constituting the foreign investment to Azerbaijan if the funds were imported in cash, or extract from the bank account confirming the transfer of funds to Azerbaijan if the funds are imported through a bank transfer, and document confirming the investment of these funds in the economy of Azerbaijan. Azerbaijani legislation determines penalties for violation of currency control rules and cashless settlement regulations. I will give a few examples of such penalties, but this is not the limited list. So officials not returning their foreign currency paid in advance in exchange for the provision of goods, services, and works within 2 years after the payment are fined in the amount from 10% to 20% of the amount of non-returned currency funds, and legal entities are sanctioned with a fine in the amount from 20% to 30% of amount of currency funds that are not returned. Not receiving the funds in exchange for the provision of goods, services, and works from Azerbaijan within 180 days after their declaration at the customs office is subject to a fine in the amount from 30% to 50% of the amount of not received funds. If the amount of not received funds is below to 20,000 manat. And criminal sanctions apply if the amount is equal to or over 20,000 manat. It should be noted that in practice, administrative penalties and criminal liability applies to cases of supply of goods, since services and works are not physically declared at the customs office. In addition, the Constitutional Court has adopted a decision in this regard and stated that objective reasons for non-receipt of funds, such as the foreign buyer's refusal to pay the funds, must be taken into account if the seller has exhausted all possible and legal means of obtaining the value of goods provided, but hasn't been successful. In addition, for violation of the requirements of cashless settlements law, a financial sanction is applied in the amount of 10% of the amount of the transaction carried out in violation of the law for the first time during the calendar year, 20% for the second time, and 40% for the third and each following time. So that's it. Thank you for your attention, and I will be happy to answer any questions regarding the topics addressed by me in the question and answer section.
Thank you very much, Fatima. Thank you. Now I would like to give the floor to the last speaker for today, Şabnam Sадыгова Гусейнова. She will be covering the employment law and immigration permit requirements of Azerbaijani law as applicable to foreign investors and their businesses in Azerbaijan. Şabnam?
Yeah, hello everybody. Thank you, Ummi. And I also would like to welcome everyone who joined us today. And I'll be discussing with you my presentation on doing business in Azerbaijan from employment and migration law standpoints. So when we talk about employment, it's usually asked what are the main laws regulating employment relations. So employment relations in the Republic of Azerbaijan are regulated by the Labor Code of the Republic of Azerbaijan, and Labor Code set out the minimum labor rights and the rules for exercising of those rights. So for attracting individuals in the paid labor activity, an employer must sign a valid employment contract with the employee. When we say a valid employment contract, we mean that employment contract must meet the formality requirements. So what is the formalities? The employment contract must be in writing, signed by both parties manually, and must be stamped by the company seal. In order for the employment contract to get into legal force, it must be registered at the electronic database of the Ministry of Labor and Social Protection of the Population. So not only the notification or conclusion of the employment contract, but also all change must be registered in the e-gov.us system in order for those changes to become into the legal force. So having clarified that the employment contract must be in writing, it's usually asked what are the main terms that must be included in the employment contract. The main information that must appear in the employment contract sets out in Article 43.2 of the Labor Code. So this is mainly the information that relates to the employer, the employee, and the information on the workplace of the employee must be stated with the employee's position, the information whether the work is the primary or secondary, the labor conditions like working hour, rest time, the length of the vacation must be stated. And according to the recent change to the labor code, there are some wordings that must appear in the employment contract, and those requirements are set out in the articles, as you can see from the screen here. It's Article 304.2 or 307.1 and others. So in practice, we can receive the questions about the probationary period, how they apply to the employees, and whether it's a mandatory requirement to set out a probationary period. The probationary period may be stated in the employment contract and may not exceed 3 months period. It can be less than 3 months, but not more than set out duration. And probation period is not applicable to specific categories of the employees that are stated in Article 52 of the Labor Code. And we advise to the employers to always check whether employee falls under those categories of the employees. During the trial period, if the employer finds out that the employee doesn't perform his or her job duties and he's not satisfied with the performance of the job obligations, employer can terminate employment agreement with the employee under Section 70D of the Labor Code, subject to the providing of the notice. A notice must be provided 3 days in advance before the expiration of the probation period and must be in writing. Another ground for termination of the employment agreement by the employer can be due to the liquidation of the entity, can be due to the staff redundancy, for the gross violation of the job duties by the employer, and for other reasons that you can see from the screen. Employment contract can also be terminated for the expiration of the contract term. This is the simplified ground for the termination of the employment contract, and for this reason we usually advise employers to sign the employment contract with the employee that they are going to hire for the defined period of time. And another reason why we advise this to the employers is just because sometimes trial period might not be enough for the employers to get to know their employees and to check their professional quality. So this will also be enough for the employer to assess whether the employee actually suits for the holding position or not. And if they are satisfied, of course, they can prolong the term of the contract for the subsequent year. Documentation of the termination is one of the important parts. And regardless of the ground of the termination must be documented by an order of the employer, and order must include the information that appears in Article 84.1 of the Labor Code, and lack of any information can lead to its invalidation by the judge reviewing the labor dispute. An important note here is that an employer can only pick up one relevant ground for the termination of the employment contract. If there are several reasons, employer cannot apply all of them. Only one relevant ground can be picked up. On the last working day, employer must provide an employee with the copy of an order with the labor book, and all final payments must be made to the employer. Unfortunately, in practice, we can witness that sometimes employer can breach this requirement and can make payment or just hand over labor book with an order on the next day after termination. This is wrong, and this might lead to some dispute and conflict between the parties. So just try to avoid that. Another frequently received question from the clients is about the procedures and options of hiring foreign nations. They ask whether it's possible to hire foreign nations under the legislation of Azerbaijan. So the answer is yes. It's possible to hire foreign nations, and in order to engage them into the paid labor activity, they must have a work permit. A work permit is a document that authorizes foreign nations, foreign employees to work in the Republic of Azerbaijan. There are exemptions from the general rule that appears in Article 64. So the employees, the foreign employees who hold head or deputy head position at the branches and representative offices are exempted from obtaining a work permit. The same rule applies also to the heads and deputy heads of an LLC, at least one foreign shareholder. For those who are seconded for the business trip to Azerbaijan with total duration of 90 days within a year and on activity fields that are defined by the decree of the Cabinet of Ministers and the other exempted nations. So the work permit is issued by the State Migration Services, and the application for issuance of work permit can be submitted either in person or by electronic means. The revision period, it can vary from 10 to 20 working days, and the work permit is usually issued for up to 1 year. If, let's say, the contract is signed for less than 1 year period, in that case, the work permit will be issued for the duration of such an employment contract. And it's prohibited to hire an employee prior to obtaining a work permit. So firstly, the an employee must get a work permit. I mean, employer must apply to their employees for work permit, obtain that document, and afterwards they can sign an employment contract. Along with the work permit, employee can be requested to apply for a residence permit, and a temporary residence permit is issued for the period corresponding to the validity period of the relevant work permit and may be extended a limited number of times. And before applying for work permit and temporary residence permit, and the employers, foreign nations, they will be required to come to Azerbaijan, and they will be required to obtain a visa. Exemptions applicable to those nations who are exempted from visa requirements. And visas can be obtained either from consular officers or from electronic portal. And after arrival to the country, they will be required to get registration upon place of stay within 15 days. So this is a short insight that I would like to provide you concerning employment and migration laws. I hope it's going to be useful for you. And if you have any questions, I will be happy to answer them. Thank you.
Thank you very much, Shabnam. That was really interesting, and I do believe helpful, as many companies, especially those that belong partially or in full to foreign shareholders, foreign founders, they do tend at least to hire few employees from their head company, at least for the first period of setting up the business here. And these permit questions and related, unfortunately, some difficult issues in practice are encountered by them. So we have some questions here in the question and answer box. I will be asking those questions to those whose topics were most closely related to the question. So the first question already answered by Royal, I see here in the question box, but still maybe other participants would also like to hear the answer. Royal, the question was about double tax treaties, and the question is, any chance Malaysia have double taxation? Royal? Is there a is there an agreement on avoidance of double taxation, if I understand the question correct, with Malaysia?
No, there is currently no a double tax treaty with Malaysia. We are not aware of any ongoing negotiation to sign such an agreement. And I see Mr. Alisher asked to provide him with list of 55 countries with Azerbaijan has signed double tax treaties. I shared with him the link to the list of double tax rates, which is in official website of tax authority.
Okay, okay, thank you. Another question here is about, I believe, business credits. Are business credits available to foreign companies in Azerbaijan? Well, I believe by foreign companies, listener meant a company or a subsidiary established by a foreign founded company. Colleagues, if you don't mind, I will ask the question. Business credits are available, and it doesn't depend on who the shareholder is. In fact, it may even work for the benefit of an entity here in Azerbaijan applying for a business credit if at least one of the shareholders is a foreign legal entity with a good reputation, with document about good standing from a foreign similar financial institution to the one that local subsidiary is going to apply for a bank credit. So short answer is yes, business credits are available for foreign companies, subsidiaries, or permanent establishments in Azerbaijan. Another question here, if I'm not mistaken, was related to the employment law. Yes, the question is long. I'll try to pass a short version. As I understand, the founder has two entities in Azerbaijan. One is in the LLC form, another one is in the form of a branch. And the listener is asking, we are transferring the employees from the representative office to our LLC. What if some of the employees are not happy with this and do not want to be transferred? If I understand the next question correctly, the question is about what payments are due, what risks, what do you recommend to avoid any risks related to transfer? Shabnam, would you like to answer, or you'd like me to address this question?
Yeah, I will address this question. And generally speaking, the concept of transfer of the employees is not provided under the labor code, and transfer of the employees is possible by the termination of the employment contract with the current employees and rehiring them to the entity that they want to switch. So first of all, they will be required to terminate employment agreement with all employees and then rehire them to another entity. So that's the procedure. And I believe there was a second question, what to do if some employees doesn't want to be transferred. So in order to answer this question, of course, we need to observe and analyze the employment contracts of those employees and to see under which grounds of the labor code termination will take place.
Thank you, Shabnam. I would like just to add, I think there was a question about what we would recommend to avoid risks, and Shabnam addressed that. I'll just add that there are different grounds for termination of employment agreement. And since for transfer, in the meaning that you would like to implement in Azerbaijan to just move employees from one entity to another, there is a need to officially terminate the employment agreements. And you, as we see, have few employees who are not happy with such a transfer. Then you may consider different grounds for termination of their employment agreement compared to those who will be happily transferred. I mean, by signing a resignation letter for termination and then by entering into a new agreement. This is for those who are in agreement with the employer to be transferred to a different company. By transfer, again, I mean not legally transferred. That is not possible in Azerbaijan, de facto transfer. And with those who would not like to do that, you may consider other grounds for termination. If, of course, a reason for transferring the employees from one entity to another is to liquidate the first company or entity after the transfer of employees. If there is not going to be any business after transfer of all employees to another company, for subsequent liquidation, you will in any case have to terminate the employment contracts with all employees. So you will just consider different legal grounds for termination, if you'd like, of course. If the employee is one of those that is very crucial for your business, you will be choosing peaceful negotiation grounds. If it doesn't matter whether the employee stays with you or not, you will be going with termination on more aggressive grounds. Here, I believe I saw a question about foreign court judgment. Yes, we have a court decision from Ukraine. Will it be possible to collect the debt owed to our company in Azerbaijan through that decision without going to the court in Azerbaijan? Well, I'll answer this question. Yes, it's possible, of course. The requirement of the law is to have a foreign court judgment or decision recognized in Azerbaijan, and then mandatory enforcement will be possible. Recognition is done through the procedure called recognition by the Supreme Court of Azerbaijan. This is very frequent practice, at least for our company. Foreign companies, they, and most of the time, they prefer to not go to local courts for reasons. For some, this is due to a reason that their head company is located abroad and the head company is the one who will be directly and constantly involved in the court procedure, or because before entering into the agreement with the company that was selling or buying goods from our client, they already mentioned a place of court in their agreement, and that was stipulated as a foreign court. They do tend to have their case adjudicated abroad and approach lawyers in Azerbaijan with already issued decisions. Again, the procedure is very straightforward, although it does take some time. It is not that fast, especially during pandemic. But the procedure is only about having all documents required by the law for such a civil procedure in the court to be provided, again in the same format, apostilled or legalized. We have them translated here, apostilled or notarized again. We go through the Minister of Justice first, and then approach the Supreme Court for the hearing of the case. And for recognition, the law has a certain set of requirements. Not all court decisions taken abroad will be recognized. And that is very important to note that such requirements that you may see in other countries' laws, for example, timely sending notifications about court hearings to the opposing party, providing conditions for the other party to respond, to provide the evidences, and etc. These kind of formalities are to be proved in Azerbaijani Supreme Court room as already followed in the previous court's hearing. If we are successful and we prove that the court decision issued abroad was taken on procedural-wise legitimate grounds, Supreme Court will be accepting the application and issuing a decision on recognition of foreign court judgment. Local Supreme Courts And this is, by the way, one of those questions that we frequently hear. Why would your Supreme Court hear the case again? This procedure that I just described is about recognition and sending to enforcement of the decision. It is not about hearing the case on the merits. Facts, disputes, proofs, evidences are not going to be re-reviewed by the Supreme Court here. The only thing that Supreme Court judges have to pay attention and ensure is that local procedural requirements were observed in the foreign court, and I'm not about procedural requirements regulating the court hearings. It is about due notification of the opposing party with the aim of respecting the human rights and other protections that our residents also have under Azerbaijani laws. And by the way, if the decision is issued by foreign court, recognition will also depend on whether Azerbaijan has already entered into an agreement that provides for mutual recognition and enforcement of court decisions issued in Azerbaijan and in the country that signs the enters into the same agreement. If there is no such an agreement, then principle of reciprocity is applicable, which basically means if in practice, although there is no treaty or agreement where parties undertook an obligation to recognize and enforce each other's court decisions, in practice we see that that does happen. Foreign court judges have already issued in their practice decisions recognizing the decisions issued here, and this has been successfully practiced abroad with respect to Azerbaijani court decisions. Then the law provides for possibility to answer with the same, even in the absence of an agreement, an obligation to do so. Coming to the Ukraine, Ukraine is one of those countries that is a party to several agreements signed within the framework of Commonwealth of Independent States, former Soviet Union countries, as previously discussed. And there are sufficient legal grounds for Ukraine to have its court decisions recognized and enforced in practice. And we do have many such decisions successfully recognized and enforced. Again, the only requirement is that during the hearings abroad, during court meetings, during the whole process of adjudication abroad, parties ensure, I mean the counterparty, if in such case the decision is against local resident company here, if they ensure that all requirements applicable to the procedure abroad is observed, is complied with, and the local resident in the first place, they were timely and in full informed about the case abroad. Here I would like to add about arbitration as a last point. I know we have already taken a lot of time of our listeners. Arbitration has also similar requirements and approach by Azerbaijan, meaning almost the same requirements that will have to be complied with by parties to a dispute that chose to have their case heard and resolved by a foreign court will be exactly the same with respect to the arbitration cases abroad. And the same requirement to have them first recognized, then directed to enforcement will be applicable. Here, legal ground is the New York Convention on International Arbitration, Recognition, and Enforcement. And with the countries, unlike Ukraine, with many countries globally, Azerbaijan does not have bilateral or multilateral agreement on mutual recognition and enforcement of their court decisions. For these cases, we usually provide pre-advice at the time of preparing the business agreements to go with the wise choice, meaning it would always be better to choose arbitration than foreign court, depending on which country we are talking about. As Azerbaijan, again, is a party to the New York Convention on Recognition and Enforcement of Arbitral Decisions, which has vast majority of the states globally signing the same agreement. So we have stronger legal base for recognizing foreign arbitral decisions than for enforcement of foreign court decisions. For Ukraine, I hope I answered the question. We can and we do get Ukrainian, Belarusian, and other country decisions recognized and enforced in Azerbaijan. I think we do not have other questions open. I think we answered to them. Here we have from one of the listeners. Thank you for excellent presentation. You are more than welcome. Thank you all for joining us today, for your interest to today's topic and the webinar, for the questions you sent. Please feel free to approach us with further questions that may arise later after the webinar via an email or phone calls, as I see in the participants list many familiar names, via Skype, Zoom. We will make sure that we allocate time for a call with you in case you'd like to go to the depths of the details of today's discussions. Thank you all and have a nice day.